All right, John Moore. Hello. All right, Mr. Moore, we're going to be brought back, and we're gonna have you brought back on March 23rd. Your case in the magistrate's court is set on March 2nd. So once that's done, then we can bring you back. If they're able to get to you sooner, we'll receive notice that they've seen you sooner and we'll have you brought back over sooner, okay? All right, thank you.
Thanks,
No,
Rob.
you're
That'd
welcome.
be excused.
Yes,
And that was March the 23rd, correct?
yes.
Thank you.
Norma, if you put more on March 23rd,
That is the back side.
no, not as a phantom date.
You want me to put it on discovery?
And may I be excused?
Yes, no, you can put it under status. Yes, you may be excused.
Thank you.
You're welcome. Darren Villarreal. Hello.
Hello.
So why were you late for court today?
Just a line outside, I was wrapping around.
All right, so here's the thing. You cannot be late for court. You understand? It's at 9. But I do appreciate your dressing appropriately. All right, on this case, who is the state? I think it's Criminal Trial Division. It's on page 8, Mr. Villarreal. All right, so you'll need to confer with defense counsel off docket to tender them an offer. Your attorney couldn't be here today. So I'm going to set you for a plea deadline date. Your attorney will confer with you on the state's offer, okay? All right, Ms. Ferguson, I need a plea deadline date. How old are you? 18. Do a plea deadline date for this case at the beginning of February.
We can do February 5th.
All right, so we're going to put you down for February 2nd. On that day, your attorney will have spoken to you about what the offer is, and you'll have all of January to think about whether or not you can reach an agreement with the state or not. If you can't reach an agreement, what's going to happen on that date is your next date after that date will be a jury trial date. You understand? All right, once you sign the reset form, you're excused. You're welcome. And don't leave before you sign the reset form. All right, just have a seat and they'll call you up. Donna Gonzalez. Hello, how's it going?
Good.
Getting closer to Christmas.
Yes.
Is anybody ready? No. Are we ever ready? No.
I am.
Hello, good morning. So why were you late for court?
I was here at 9, but the Uber driver was taking me a little further down rather than.
All right, so now you know where you're supposed to be.
Yes,
And
ma'am.
so court starts at 9, okay?
Yes, ma'am.
And thank you for dressing appropriately for court. All right, so on this case, where are we on discovery?
I think we have all the discovery. I think you need to talk to her.
All right, and was the state able to tender an offer?
We do have an offer now.
All right, Ms. Ferguson, set this for a plea deadline date at the beginning of January, please.
Can you do January 8th?
All right, so we're going to be back on January 8th. On that date, you'll need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date will be a jury trial date, and it'll probably be a quick turnaround, okay?
Okay.
All right, just have a seat. Once you sign the reset form, you'll be excused.
Okay.
All right, thank you.
Thank you.
You're welcome. All right, are the parties ready on John Anthony Cruz?
Yes,
All right, the court is called.
we're ready.
All right, court is calling 2025 CR 0080006 State versus John Anthony Cruz. Could I have parties announced for the record for the state?
Charles Bunt for Mr. Cruz.
And are you Mr. Cruz? All right, you entered a plea of guilty to count 2. You applied for probation. There was a PSI and TAP evaluation completed. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Any objections from either side?
No.
According to your plea bargaining agreement, The state is opposed to your application for probation. Punishment is to be assessed at a cap of 10 years in the prison, and there's a $1,500 fine. All right, this is what I can tell both parties. State, I understand why you would be opposed to his application. I reviewed his criminal history. The cases where he's done poorly on probation was a misdemeanor case according to the PSI report. It appears that the other case, which were also possession cases, there was no application for probation in those cases, and he was just sent to prison. One for 2
2
years,
years, and one
one
for
for
4
4 years.
Yes.
I think the PSI on his Medina County history reflects a case he did have felony probation on.
All right, let me find that.
On page
It should be right after the Bear
Yeah.
County history,
All right, so on that one,
2015.
all right, for that case, you were given probation, you were revoked and sentenced to 5 years. And again, that's possession of drug case. What I see in the TAP evaluation, it says you have a dependency, and a lot of it is related to synthetic drugs, which are extremely dangerous. This is a possession case. It's not an intent to deliver case. If it were a possession with intent to deliver, we'd be maybe somewhere else on what my thoughts were. So if there's anything that anyone wants to add, I'm going to give him a choice. Here's your choice. And there are no other choices, so don't ask for anything else. Number one, I'll grant your application for probation. The state wanted your punishment to be assessed, so I would find you guilty and sentence you to 10 years in the prison, suspended and probated for 8 years. You'll be going to safety. You will not be released. I would follow the TAP recommendations, or I'll sentence you to 6 years in the prison. Those are your only two choices. And state, the reason why I'm doing this is obvious that he has a drug issue. And if we keep pushing this down the line where he just does his time and he's done, then what's going to end up happening? He's going to be back. So those are your only two choices. Which do you prefer, or do you need to speak to your attorney?
Can I speak to him?
Sure.
Because I did have some witnesses if the court wanted to hear from them, but I think we may not, that might not be necessary. Let me talk.
Okay. All right, who's here on Fernando Trujillo?
Tag team, Judge.
Yes. All right, do you all have the update on his federal matters?
February the second, jury trial.
I'm sorry, what?
February the second.
February 2nd.
Second, 26, second jury trial.
All right, Ms. Ferguson.
You would step out to make a phone call, Judge?
All right, we're gonna reset this, and I'll reset it for March, and we'll just see where we are. Let me look on the calendar.
All probability we'll be back again.
Oh, yeah.
I think, I asked somebody that this a lot better work, says, oh, you're gonna drop on sometime in 2027.
Oh, yeah. So what we'll do, and if y'all can pull out your calendars and tell me, all right, I'm gonna set it the week of March 23rd.
Okay, Judge.
So any date that week?
That way.
All right, we'll set it for March. Let's put it for March 26th. And we'll see where we are.
Thank you. Maybe Tuesday.
Yes.
Thank
What day?
March the 26th.
Yes, ma'am.
Watch it.
Oh, and state on Trujillo, if you can make sure that the defense has discovery on that, on those two cases.
We've already done discovery knowledge.
Oh, okay, awesome. And well, state, if you'll make sure they have an offer. Vasquez Solis. Good morning.
Morning.
Let's see. So was an offer tender,
Yes, Your Honor.
and how old are you?
48, 49, sorry. Pretty good.
Okay. All right, we're gonna recall this for January 8th. That will be your plea deadline date. All right, once you sign the reset form, you'll be excused. And counsel, if you can make sure that state has done an acknowledgement of discovery.
Yes, Judge.
All right, thank you.
I'll give them a reset.
Thank you. All right, are the parties ready on John Anthony Cruz? All right, we're back on the record on 2025 CR 008006. Could I have parties re-announced, please?
Charles Bunk for Mr. Cruz.
All right, you're Mr. Cruz.
John Anthony Cruz.
All right, what have you decided?
On the probation.
Judge, he wants preparation. He's, as you can tell from the PSI, he's begging for help. He's very thankful that you're giving this opportunity. He wants to take advantage of it.
It's not.
And just so you'll know, he does have family present in the court who are supporting him in his endeavors as well.
Okay. All right, state you may be excused. This is what the court will do. The court is finding you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years, $1,500 fine. That will be probated. There's to be proof of employment within 60 days of release. There's to be no employment as a home health care provider or with minors. No residing in households with minors. Field visits 1 time per month until further notice. He's to remain in custody for the following. And that's remain in custody for transfer. Just 1 second. And it's for a transfer to SafeP. And Ms. Abrams,
Yes, Judge.
if you could also do a referral to felony drug court. I know they're full, but maybe, after the new year, they'll have room. And there's a restitution amount. I believe it was $120. Yeah, there's to be restitution of $120 to SAPD for drug testing. Regular reporting by Zoom or in person. Regular random UAs. There's to be 350 hours of community service restitution. There's a deduction of 1 hour for every sober support meeting completed. And I am going to order sober support meetings 1 time per week until further notice. And you're going to have to make sure that you get a sponsor to help you. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. It appears that you've been using drugs for a very long time. So it's going to be extra hard on you. You need to remember this day and remember that you were this close to going to prison for 10 years. And you need to start making decisions. I always tell people, and what I've learned from taking courses is that you have to want to be clean for yourself. But if you don't feel like you're worthy of being clean for yourself, then you need to do it for your family members, because otherwise only 1 or 2 things going to end up happening to you. You're going to come back as a habitual offender. Your minimum is going to be 25. You may not have this attorney. You may not have these prosecutors. You may not have me as a judge. And you may end up spending the rest of your life in prison, or either you're going to end up with some drugs, right? And people who make drugs, really all they want is repeat customers. So you really don't matter to them. They're not following FDA protocol when they're making their drugs. And the last time you use may be the last time you use. And your attorney will tell you, in this court, I take no pleasure in sending people to prison, but I will. If there is an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back here and we will address it. Do not disappear on your probation. And when they do those home visits, you need to make sure you're available. You understand? All right. Good luck to you. You're welcome.
Thank
Thank
you,
you.
Judge. We'd be excused.
Yes.
Thank you.
Well, not him.
Not him.
Yeah.
All right.
There you go. Anyone else ready?
Homer Solis?
Thank you, Judge.
You're welcome. Bye-bye. I'll be a support system for him, okay?
Well, we're gonna make sure that he's taken care of.
All right, thank you. And if there's any issues, please let probation know so we can make sure that he stays on track.
Yes, ma'am.
Thank you. All right, you're welcome. Caroline Herrera. All right, let me see what we have here. All right, hi. Thank you for dressing appropriately for court. Today is your plea deadline date.
Yes, Your Honor. Mr. Van Heinrich is in Kerr County and will be out of county all next week. He's just asking for a little more time. Finish reviewing discovery, get the plea in.
So is this going to be disposition?
As far as I know.
All right. Then Norma, recall this for December 18th. That will be the final plea deadline date. The court will not extend any further. All right, thank you. Once you sign the reset form, you're excused. Just have a seat and they'll bring it to you. You're welcome. Joe Ramos. Good morning. Thank you for dressing appropriately for court. All right, so we're actually set for jury trial. We're
don't-
currently in a jury trial.
Okay, we don't have an agreement still. so-
Okay. All right, Ms. Ferguson, I need a jury trial date. How long do you all think this will last?
Couple of days, 2 to 3 days, maybe.
All right, Ms. Ferguson, can you put this in February for jury trial, please?
February 3rd.
All right, February 3rd will be your jury trial date.
Okay.
Any questions? All right, once you sign the reset form, you'll be excused. Just have a seat. Your attorney will bring it to you. All
Okay.
right, thank you. Thank you.
Thank you, Judge. Okay, we're finally ready.
I messed up today. I made a mistake. I told my client that I would apologize to the court. I left documents that she gave me, and it's not something I can go across the street and get. It would take about 2 hours to go get them and come back.
Mhm.
I still have other settings this morning.
All right, who is this?
Audrey Bash. It's a PSI sentencing. I can tell you that I can sit here, review the PSI with her for the next 30 minutes, talk with her 45 minutes, as long as we need, so that tomorrow morning we will be ready to take it up without having to confer. If tomorrow, I could be here first thing tomorrow morning.
Mhm.
I don't have any settings tomorrow. I know you're likely in trial.
Mhm.
But if I was here sharp 9,
Mhm.
if not, if we could recall something to Monday where I have the documents that she gave me. And it's just that I failed to bring them to court today.
All right, just a moment. All right, we're back on the record. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. The state is proceeding on count two, possession of a controlled substance penalty group 1 gram to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, if for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Counsel. Do you believe he has a rational as well as a factual understanding of the charges against him?
He was,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes to both.
Mr. Alatorre, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
Yeah.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived in jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2, waiving count 1. There's $1,000 fine. State recommends deferred adjudication. They were taken in consideration 2025 PF 07403. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge, but I forgot to go back to the prosecutor. She in 5 years. The agreement was for 5 years.
No, you can't agree to the length.
Oh, okay. I thought we had I thought it was in the file.
Yes, below.
Oh, okay. Very good.
So did you understand that to be the plea?
That's our agreement, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No,
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State Officer States Exhibit 1 and all attachments.
I reviewed those documents with my client. We have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
All right, I'm gonna need you to speak up.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, state defense. I endeavor to stay in my lane, but this is a possession, 1 to 4 grams. And the weight of the drug, according to the lab report, is 1 gram plus or minus 0.02 grams. So if y'all still want to go forward with this defense, I will, but the range of punishment, I'm sorry, the offense is possession of a controlled substance, penalty group 1 gram to 4 grams. They did the weight of the drug, and when they did the weight of the drug, it's 1 gram plus or minus 0.02 grams.
I noticed that as well, Judge, and I discussed that with my client. Considering what the original offense was, we thought that was a good middle ground.
Okay, I mean, if this is what you all want to do. All right, thank you. All right, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Nothing other than, as the court can see, this is his first offense, hopefully his last offense. He has no priors other than a couple of pending cases rising out of the same offense. A date in.
What are the pending cases
this
arising out of
court.
this offense?
I think it's a UCW and a reckless driving.
And he doesn't have any other criminal history?
That's my,
If no one criminal history, the defense counsel said the reckless driving did step from this house, taken into consideration, and then the UCW is gonna be filed in rent.
All right. Court is going to sentence you to 2 years deferred adjudication. There's regular reporting by Zoom or in person, regular random UAs. Are you currently employed?
Yes,
Doing what?
I work at AutoZone as a commercial driver, Your Honor.
Okay. Proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have any children?
Your Honor.
All right, there's to be a TAP evaluation out of custody, follow recommendations. Do you live with anyone who has children?
No, I live with my grandmother, Your Honor.
Okay. No residing in households with minors?
No, no.
Oh, that's what I'm ordering. But thank you for letting me know. There's to be 120 hours of community service restitution. What's your dream job? Are you doing your dream job or?
My dream job is, I'm not currently doing my dream job. My dream job is what I'd like to say. I wanted to apply to be an electrician. I already had my electrical apprentice license. I just need to go and like do like hours. So I've worked under like master electrician for a couple hours, but I need to reapply for my electrician license.
All right, there'll be 120 hours of community service restitution. If you obtain your trade school certification or whatever certification you need, be it to be an electrician or a welder or whatever it may be, the community service hours will be deemed satisfied. Otherwise, you're going to have to do the community service hours. There's going to be field visits 1 time per month for 3 months. Probation, is there anything else? Anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand, Your Honor.
All right, we've got the record in this court to be successful. Communication is key. Do not disappear on probation. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with me. You understand? Now, as a side note, here's my question. The piercings on the cheek, does that hurt?
No, Your Honor. I mean, it's a pinch.
Oh, and do they go underneath the skin? I always wonder if you want it yourself, are you able to do that or no?
This one specifically it doesn't need a doctor to put in, so I can remove it by taking off the top, and it's a bar under my skin.
Oh, do you just unscrew it or?
Yeah.
Okay, I always have these questions. All right, good luck to you. Just probation will go over conditions with you, then you'll be excused.
Thank you, Your Honor.
You're welcome. Jan Majora,
I'm a little slow on this case. I'm covering her baby that's out on paternity leave right now. So
Okay.
I First myself up on it.
well, the first thing is we're supposed to figure out what the restitution is.
Judge, my client's decided she's not going to contest the amount.
Okay. And when will she be able to pay this?
She'll have to pay it off during probation, Your Honor. She's already paid a substantial amount up front. So
I'm sorry,
about
how much?
1,077 and
Yeah, it was almost 11.
almost 1,100.
1,100.
So when do you anticipate paying this $1,077?
No, that was already paid.
Your Honor, she's paid that already to to the Junior League of San Antonio. The remaining is at the bottom of that where it says Kings Keep Berkshire Hathaway in the amount of $9,799.42 and then $227.71 to Visa. So that's the remaining.
All right, so how much are you gonna pay monthly towards that?
Excuses, I need to.
Well, now, here's the thing. I'm going to order you to pay specific amounts monthly. So you need to tell me how much you're able to pay per month. All right, is that what you think I want to hear? Is that what you can do?
That's what I can,
Okay,
barring any changes in my life, that's what I can do.
okay. All right, court is calling 2024 CR 011624 State versus Jan Madura. Can I have parties announce?
Andrea Crespo standing in for Chandler Bowen, Your Honor, ready to proceed.
Linda Corley for defense.
And you're Miss Madura.
Yes, ma'am.
All right, based upon my calculations, you should be able to have this paid off before the 2 years. Do you understand? If you're paying 500 per month. All right, so we're here for sentencing today, and we were called back because there was a matter of restitution. Are both parties ready to proceed with the sentencing?
Yes, Your Honor.
Yes, Your Honor.
All right, this is what the court will do. Your agreement was for deferred adjudication, so the court will sentence you to 2 years deferred adjudication. The court will show that restitution of $77.01 was previously paid to the Junior League of San Antonio. Remaining restitution is $9,799.42 to Berkshire Hathaway and $227.71 to Visa. Restitution is to be paid in the amount of $500 per month. There's to be regular reporting by Zoom or in person, regular random UAs. Are you currently employed?
Yes.
And what do you do?
I am self-employed. I do contract work, accounting work over online.
Does anyone have any issues with her doing accounting work? And is this accounting work that you're doing, is there any exchanging of money?
No.
All right. Then proof of employment within 30 days, no employment as a home healthcare provider or with minors. There's to be 80 hours of community service restitution, field visits 1 time per month for 5 months. Probation, is there anything else?
Yes, Judge. I think so. Which count?
Oh, I'm so sorry. They proceeded on the lesser included offense of theft, $750 to $2,500.
Okay, Judge.
And they're proceeding as a Class A misdemeanor.
Then, as far as the restitution is concerned, can you please give me those names?
All right, the,
I have Berkshire Hathaway.
yes, Berkshire, Hathaway, Hathaway. And then the $227.71 to Visa.
He said Visa.
Yes.
Nothing else, Judge.
All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So in this court, to be successful, probation communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to the court.
Yes, ma'am.
All right, and thank you for dressing appropriately for court, but you always do. I appreciate that. Thank you.
Thank you, Judge.
Court is calling 2025 CR 010997, State versus John Jacob Gomez. Could I have parties announced for the record?
David A. Garcia, attorney for John Gomez. Good morning, Your Honor.
Good morning. Are you Mr. Gomez?
Yes, Your Honor.
All right. Both parties waived PSI.
We did, Judge.
According to your plea bargain agreement, punishments be assessed at a cap of 8 years in the prison. This run concurrent with 2023 CR 6499B. The state is opposed to your application. Is he currently on probation?
He's on parole, Judge.
Parole. Right. Are there any do you have any witnesses? Defense, any witnesses?
And Judge, I think the case that he's on parole for is a 2003, not 2023.
Oh, I'm so sorry. 2003 CR 6499B.
No witnesses, Judge, just argument.
All right,
Your Honor, the state's position is that Mr. Gomez is not fit for any type of community supervision, but rather for incarceration. He has already done 3 previous trips. The most recent being for an ag robbery in 2004, so because of that.
all right, defense.
Judge, I understand the state's argument. On paper, it looks bad, but Mr. Gomez here, he went to prison for a case out of 2003 for an ag robbery. He sat in prison for about 17 and a half years. He got out on parole, has been working at Paisano's restaurant as a chef for the last 4 years. He was helping to raise his three boys, helping his elderly mother. Everything had been going well. He was doing well at work. What was the name of the chef you were working under?
Under Chef Raul.
Under Chef Raul, he had high hopes. And it's true that the path to hell's paved with good intention, Judge. His brother needed someplace to stay. He felt he couldn't let his brother live out on the street, so he let his brother live with him. Unfortunately, the brother ended up having a warrant for his arrest. When a warrant was executed at his house, they came in, they found the brother, they found a gun. Because it's his house, he was charged. Mr. Gomez knew he could take this to trial. He didn't want to waste anyone's time, waste the court's time. He knew that he made a mistake by having his brother live there. It was his house, thus he was in possession. And so we took this plea. We're hoping that you give him this opportunity to prove himself. I know it's based on his record, it looks bad, but you know, he did spend his time. It was 22 years ago that the ag robbery occurred, and he was trying to do well. If you can give him an opportunity, he can prove himself, Judge. He's willing to abide by any condition.
All right, is there anything you wish to say?
No, Your Honor.
All right, in the stipulations, you admitted that you're the person who purchased the weapons.
Yes, Your Honor.
All right, so, I mean, I don't think you're a good candidate. I mean, you should have known, you can't purchase weapons. All right? So, the court is going to find you guilty. The state is asking for a cap of 8 years. Is there any argument with regards to the cap?
Just simply, Judge, that he was trying to do well. He knows he made a mistake. He's accepting responsibility for it, Judge, by taking this plea and not making the state take him to trial and waste the court's time. So we're asking that you be as lenient as you can.
All right, and state.
The cap is more than generous considering the prior criminal history, so we just ask the consent.
All right, the court will follow your agreement. The court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2023 CR 6499B. I'm sorry, not 2023. It will run concurrent with 2003 CR 6499B. Is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and as you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You know what position you're in. You know, if you don't know, if you didn't know before, you now know. You're not allowed to possess weapons. You're a felon, right? And you shouldn't let anybody in your space that is going to potentially result in you being charged with something that's illegal, because you know what you're facing. All right, good luck to you, okay?
Yeah.
Yes. Joshua Sutherland. All right, today's plea deadline date.
So I spoke with the prosecutor. He got me the discovery that was missing. We just needed a trial setting judge.
All right, how long? All right, Norma, I need a jury trial date, February. And I need an acknowledgement of discovery.
I'll get that done, Judge. I'll have that turned in.
All right, your jury trial date is going to be February 24th. Your plea deadline date is expired. The court will not accept any plea bargain agreements in this cause without good cause. Do you understand? Otherwise, you have to plea open to the court. All right, just have a seat. They'll bring the reset form to you. Derek Lopez. All right, and with regards to that on the system, they say that's something the clerks don't handle. Will have to be done. Maybe you can talk to Lance.
Okay, I will talk to him.
All right, Mr. Lopez, it's listed on the system. I told your attorney, and the state is aware and the clerks are aware. On the printout, it says you're a fugitive, but obviously you're not a fugitive and there's no warrant that's listed for you. I don't know if what is on this document goes to officers or not when they're driving around, but your attorney will check into that. So if for some reason, if you're pulled over, just be kind and know that your attorney will take care of it and know that it's a mistake, but don't get upset, because when people get upset, that usually ends meaning other charges.
Yes, ma'am.
All right, so we're here for discovery issues.
Judge, so I'm not sure who's handling this before. I did have a chance to confer with Mr. Fox today. The defendant does have an unindicted case in which there is outstanding discovery. I have made a request to pull the discovery that we do have on the case so far and have it uploaded to the case that is indicted. That way Mr. Fox will have an opportunity to review that and advise.
All right, and what degree of felony is the unindicted case?
Second degree.
All right, is that,
At large though, so I can't, it's not something that can be appointed on, so they're having to, for that reason, the discovery that's there, they have to put it onto this case number, so that's what they're doing now.
all right. Ms. Ferguson, if you can recall this for discovery in January, please, towards the end.
Vision, I did make the request today for it to be uploaded to the third case.
That's fine.
All right, so what we'll do is on January 29th, make sure all the discovery is in and state if you'll be prepared to tender an offer at that time.
Thank you, Judge.
All right, thank you for dressing appropriate for court. Once you sign the reset form, you'll be excused. Just have a seat. Your attorney will bring it to you.
Thank you so much, man. I hope you have a good day.
All right, you too.
Thank you.
All right, Joe Rodriguez. So, Mr. Bonk, on this case, these cases,
Yeah, there's a bunch.
yeah, where are we on discovery?
Think that I have everything now.
All right, has the state been able to tender an offer or no?
Yes.
All right, then what we'll do is I will recall this back.
Can we come on that same day?
Yeah, we'll
Okay.
put it, Norma, put this for a plea deadline date on January 29th.
Yes.
And state on Joe Rodriguez, if you can do acknowledgements of discovery for the court to sign, please. All right, do you have any questions about anything?
No, ma'am, I was just talking to my attorney. Because there was an offer today.
Oh, so what ends up happening, the state will tender an offer, you and your attorney will have a chance to discuss it. And maybe your attorney will make a counter offer. I'm not really supposed to know about what any offer is until I accept an offer. All right, so we'll come back on January 29th.
Thank you, Judge.
Thank you. And Mr. Bonk, if you'll make sure you sign the acknowledgement of discovery on that one.
Yes, Judge.
James Matthew Gonzalez. Hello. Good morning. So y'all have received all discovery?
We have, and the state has extended a recommendation of pretrial diversion, so we're asking the court to give us time to make that application.
All right, if you also could also do an acknowledgement of discovery for me, please. And I need a PTD date.
Yes, ma'am. I can do January 12th.
That's fine.
All right, once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court.
All right, thank you.
Thank you. Luis DeLeon. Oh, Patrick Valentine?
He's just getting a signature.
Oh, okay.
He's right there.
Hi, Hunter. How's it going?
Oh, Judge, it's good. Just trying to get a lot done before the holidays.
Ah, are you ready?
For the holidays, absolutely not, Judge. Emotionally, yes. Practically, no.
Oh, gosh.
Can I beg just a moment to go grab Jay in the hall?
Hello, no problem. So today is set for a contestant.
So this, I just wanted to wait for counsel.
Yeah.
Please. So Judge, in talking with the witnesses, as mind you, this is a first setting. So we had a bond hearing previously and it was
Yes.
separate contested. So in talking with the CSO and then witnesses that are part of the allegations currently on the MTR, it sounds like there is another incident that could substantively affect the allegations on the MTR, potentially other cases that I have not been able to flush out yet. This is information we received about 3 days ago. So courtesy to defense, I let you know. I'm trying to see if there's any law enforcement response and police reports associated with that. But we'd ask for a little bit of time to get that information.
Obviously, if we were to go forward with it, we want the court to hear everything. It makes no logic to file a new MTR down the road if there's new allegations. But also, we have filed a motion to withdraw based on Mr. DeLeon has had an inability to.
All right, do you have the motion?
I have a copy. It's been e-filed, Your Honor, but
All right, are you aware that your attorneys wish to withdraw?
They told me that right now, we were talking and I wasn't aware that this was gonna keep moving forward. But they were continuing to withdraw. We were talking right now and so, I mean, can we talk or?
no, Judge, I think the allegations keep growing and the obligation is not. So I think in fairness to Mr. DeLeon, if he is
Well, now,
gonna.
here's my question. Right, they filed a motion to withdraw. Here's the thing, in this court, I like to take things in an orderly fashion. Before I even address this reset, I want you to speak to your attorneys about the motion to withdraw, and they will explain to you why they're seeking to withdraw. Either you agree to their withdrawal or not. If you don't agree to their withdrawal, I'll still have a hearing on the motion to withdraw today. Because if I were to grant it, I don't want you to be in limbo with no attorney. All right? So if y'all have a seat and just let me know quickly because we're gonna recess this morning docket shortly.
Yes, ma'am.
All right, thank you.
And Judge Mary is calling me down at 1:44.
No, go to Judge Mary, and actually, if you could let me know,
Yes, ma'am.
what date do you anticipate having everything?
I would hope to have some information the next week or two, Judge, but I guess practically.
No, I mean, the contested hearing then will be set in the new year because,
I would think so, Your Honor.
yes. So,
Uh,
no, I haven't ruled on your motion yet. But if you can confer with Norma,
Yes, ma'am.
just to have a date for you in case I grant their motion to withdraw. So if you'll just confer with her before you leave, and then I can take this up without your presence, because it appears that if he stays on, he's gonna want a new date for the contested, and if there's an attorney that's appointed to him, they're gonna need a new date as well.
Yes, ma'am. So I'll give Ms. Norma a tentative date, and then if there is a new attorney. If
They'll have that
if that
date.
doesn't work for them, then we can confer some more.
Okay, all right, awesome. Thank you.
Judge.
Nicholas Salazar.
Yes, Your Honor.
There is attorney traffic.
All right, today is disposition. What's happening?
Yes, Your Honor, we were discussing pretrial diversion. It's not, I don't think it's gonna be an option, so I believe we can take a plea next time.
All right, next time is gonna be December 15th.
Can you do the 18th, same day as the other case?
Yes. Ms. Ferguson, if you recall this for December 18th, that'll be for disposition.
Yes, ma'am.
All right, thank you for dressing appropriate for court. Once you sign the reset form, you're excused.
Yeah.
Thank you. Jonathan Lizardo. morning. Thank you for dressing appropriately for court.
Yeah, when you.
You rival some attorneys with your attire. Yes, discovery.
Yes, when we provided everything we are able to defense, there is a discovery that feds will have to come for this to you. And I believe we are going to set up a time to do that.
Yes, Judge, just was given a bunch of stuff this morning, intend to do that. I will set up a meeting as soon as I can to view what needs to be viewed in the district attorney's office. Just asking for the time to do that so I can confer intelligently with the state. And when I get the offer, I can I can respond to it appropriately, Judge,
All right.
and determine whether or not we need to just take it to trial.
All right, you all will need to confer off docket in regards to an offer. Date at the end of January. Ms. Ferguson, I need a January date, end of January, please.
29.
All right, January 29th will be your plea deadline date.
Yes, Judge.
Do you understand?
Yes, sure.
All right, any questions?
No.
All right, just have a seat. Once you sign the reset form, you're excused.
Thank you,
Thank
Judge.
you. Manuel Ramirez. And I need the violation report. All right, what is happening with his case? It's a possession less than a gram case.
Yes, Your Honor, I apologize, but I did not receive notice of the setting, so I'm not ready. I was hoping to bring it back either tomorrow, but I was told you're in trial.
Yes.
So I was hoping maybe next week, whatever you can do, Judge.
All right, Ms. Ferguson, are you able to put this on the docket for disposition on December 15th?
Yes, ma'am.
All right, we're gonna bring December 15th.
Thank you, Judge.
Thank you.
Have a seat, sir.
All right, Luis De Leon. Yes, but can I have your motion to withdraw?
Yes, ma'am.
Are you still seeking to withdraw?
Yes, ma'am.
All right, court is calling 2024 CR 3774 State versus Luis Alberto De Leon Jr. Can I have parties announced? Just for the defense, please.
Jay Norton and Patrick Valentine.
And are you Mr. De Leon?
Yes, ma'am.
All right. State's attorney was present, but was called to a different court. The state informed the court they had no opinion on your motion to withdraw. Have you had a chance to discuss the motion to withdraw with your attorneys? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Luis De Leon.
All right, your counsel has filed a motion to withdraw. They state there's an issue with your contractual obligations. Are you aware of those issues?
Yes, ma'am.
All right, do you have any objections to their motion to withdraw?
No, ma'am.
All right, the motion to withdraw will be granted.
And Judge, while Mr. De Leon is here, Mr. Bunk asked me if I would text him and ask him, inform him if the court granted our motion. I will do that so they can come back and so we will tender information that we have to Mr. Bunk.
All right, so Attorney Bunk will be your attorney. This case is going to be recalled for January 12th for a contested hearing. This attorney will share any discovery information, police reports, whatever he has received with Mr. Bunk, so that Mr. Bunk will be able to represent you.
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
All right, thank you.
Good luck.
It's Luis Alberto De Leon Jr. He's on page 12.
Yes.
I'm sorry, what page?
He's on page 13, one down.
Is that a motion to revoke?
It's a bond hearing.
It's a bond hearing, Judge, but we're also scheduled for his case. We were just gonna request a reset to next week on Thursday. He did get accepted into VTC, but he had picked up a new case. So the state wanted to look into the new case and have a little bit of time to vet that before recommending him for potential probation with the condition of VTC, Judge. So we're respectfully requesting a 1 week reset adjournment so we can allow the state to look into that new case, Judge. But I feel, or I'm hopeful that by that time we'll have a resolution.
All right, so we'll bring you back on December 18th and take it up at that time. All right, you're welcome. Patty Jones. Hello. All right, for dressing appropriately for court. All right, today's plea deadline date.
Yes, Your Honor. There was a PTD offer made. We did the application and turned it in about 30 minutes ago.
All right, I need a PTD date, please.
January 12th.
All right, so we'll see you back on January 12th. Just make sure you keep up with everything they're asking of you, all right? All right, thank you. Just have a seat. Once you sign the reset form, you're excused.
Thank you.
Thank you. Monroe Heard,
Yes, Your Honor.
are there any applications?
Yes, Your Honor.
Probation, this is an application. And he is on page 9, the last one. Court is calling 2023 CR 7583, State versus Monroe Heard. Could I have parties announce?
Renee Munoz on behalf of Mr. Hurd.
All right, counsel, could you have them move down to the other end? And are you Mr. Hurd?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Hurd, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, the state charge is robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in the prison and up to 10,000. Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge, and if the court can recall, he was deemed incompetent previously. However, under the magistrate court, he did undergo competency restoration services at the state hospital, San Antonio State Hospital, which they deemed him restored to competency. And the matter was referred over to the 187th District Court. So after being appointed in his case and speaking about the allegations of this charge, I do feel at this current time, he has a sufficient understanding of the proceedings against him, Judge.
Mr. Hurd, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a US citizen, I'm sorry, just 1 second. If you're not a US citizen, by entering into this plea, you will be deported, denied naturalization, or re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,000 fine and the state is opposed to your application. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense of robbery, how do you plead?
No comment.
State, any evidence?
No objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right, counsel, we can go off the record.
Yes, sir.
If we do PSI and TAP evaluation, it's 8 to 12 weeks. Either way, it's gonna have to take place in the new year. Do
Right.
you want a PSI and TAP?
Your Honor, I don't believe a PSI tap will be necessary. However, we are requesting that sentencing get reset, so I have the opportunity to call witnesses and to inform them of the date, so I can advocate on Mr. Bird's behalf.
All right, which date in January would you like?
Would the court possibly have availability on January 22nd, Your Honor?
Ms. Ferguson, is January 22nd available? All right, so we'll bring you back on January 22nd. Probation, PSI and TAP are waived. All right, and at that time, whatever evidence is presented to me, the court will make a decision based upon any evidence, all right? All right, thank you.
Thank you, Your Honor.
Dakota Derek? Dakota Dirk? All right, the court is calling 2025 CR 012248, State versus Dakota Dirk. Could I have parties announced?
Renee Munoz on behalf of Ms. Dirk.
And are you Ms. Dirk?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Dirk, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Your charge is possession of a controlled substance, penalty group 1. That's a state jail less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Ms. Dirk, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,200 fine. State recommends deferred adjudication. They will take in consideration 2025 CR 012012. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 120 hours community service restitution, no contact with Michaela, Mikaela, Sousunis, Sousunis, Christopher Carter, the DOEP course, MRT, and regular random UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence.
Yes, Your Honor, state also states exhibit 1 in all.
Without objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses who remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, briefly, which also ties into our request for certain hopeful recommendations for the court in terms of the conditions of community supervision. My client at the time of this offense was homeless. She was in the midst of substance use and struggling with that disorder. She has been in lifetime recovery for the last 3 months, and she is set to graduate and complete that on the 15th of December, Your Honor. Furthermore, she is set to go to Pay It Forward at Haven for Hope to continue care under that program, and also doing a 10-week outpatient lifetime recovery upon her graduation from lifetime recovery, Judge. Being that she has been working on those things in terms of her recovery, we're respectfully asking the court if she shows her certificate of completion to lifetime recovery, if the DOEP course and the MRT course could be set to have completed, since she was learning those things at lifetime recovery for the last 3 months. Further, Your Honor, we're asking that the fine be probated. She'll be living at the homeless shelter Haven for Hope. She'll be doing AA, NA classes, and we wanted to also request of the court if she can get credit, her community service hours, she can get credit for doing the AA, NA classes, Judge.
All right. So tell me about yourself. Do you have any children?
I have 5 children, but I placed them up for adoption because at the time I was under the influence and I couldn't be a good mom at the time.
All right, that's a hard thing to do, but I'm glad you made the sacrifice for them. And I think as they get older, they'll appreciate what a sacrifice that was for you. All right. This is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. There's be regular random UAs, regular reporting by Zoom or in person. Probation with regards to the random UAs, if Lifetime is doing that and if that is acceptable to probation, you may accept those as her UAs. There's to be no contact with Michaela Susani and Christopher Carter. Continue with Lifetime Recovery followed by Pay It Forward. And also follow with the 10-week outpatient with Lifetime Recovery. You're to provide certificates. If you provide those certificates, then you will not have to complete the MRT or the OEP course. Field visits 1 time per month until further notice. There is a $1,000 fine that will be probated. Taking consideration 2025 CR 012012. There's to be community service restitution hours of 120 hours. 1 hour will be deducted for every sober support meeting completed. You're welcome. Probation, is there anything else? Proof of employment within 45 days of release, no employment as a home health care provider or with minors. Anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So you're doing great. Your attorney will let me know when your graduation is. If I'm in town, I'll attend your graduation. But this is what you need to realize. I think, right, that it's easier to maintain your sobriety when you're in an inpatient facility. And once you get out, the real world starts hitting you, right? So don't get off track. Don't look up and then you say, oh, I have this sober support meeting, but I don't have time, so I'm not going to do it. I'll just do it. Doing that, you will look up and find that you're so off your path of sobriety because time goes by quickly, okay? In this court, communication with probation is key. If there's any issue, let them know about it. If you feel they're not addressing it, you can always come back to court.
Yes, ma'am. Thank you.
Thank you for dressing appropriately for court and good luck to you, okay? All right, who's here on Sonola? Furman Monteson.
I am Judge.
All right, if he'll come forward.
He's on page 10 to the bottom.
Thank you. And I know I'm mispronouncing the last name. I'll figure out how to pronounce it. Are there any applications?
No, Judge.
All right, how do you pronounce your last name?
Sinaloa.
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 That's perfect.
All right. Now, when I say it wrong, don't hate me too much. All right, the court is calling 2024 CR 5566 State versus Furman Sinaloa. Sinaloa. Okay. Could I have parties announced for the record?
Orlando Castanen for defense. Castanen.
And are you Mr. Sinaloa?
Yes, ma'am.
All right. Counsel, have you received all discovery that you review with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
That we're waiting the picture.
No objection to that.
All right. Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with possession of a controlled substance penalty group 1, 4,200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State officer states one in the attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
All right, the court will follow your agreement, find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. Before I conclude with sentencing, so is there a drug issue with you?
Yes, ma'am.
All right, so I'm gonna recommend the therapeutic community. Legally, I don't have the jurisdiction to order them to place you in the program, but in the judgment, they will see that I'm asking that you be placed in the program. You'll still have to request it as well.
Okay.
All right, and there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
It's not.
Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
It's not.
All right, we can go off the record. Here's the thing. When you're released from prison, if you can't find a sober support transitional housing for yourself, if you can't find a facility that will help you with any type of addictions, if I'm still here, come back here, I'll pick up the phone and call somebody to help you, all right? Because only one or two things are going to end up happening. You already know. Either you're going to end up in prison for the rest of your life, or the last time you use may be the last time you use. And if you don't want to do it for yourself, if there's a family or member or loved one that you have, do it for them, all right? All right, good luck to you.
Thank you, Judge.
Thank you, counsel.
Have a seat, sir.